Greetings to all of you and welcome to the 15th edition of the Washington College of Law Annual International Commercial Arbitration Lecture. My name is Paolo Di Rosa. I head the International Arbitration practice at Arnold Porter. My law firm has had the pleasure of sponsoring this lecture for over 10 years now. This is the first time that we are broadcasting this lecture over the internet. Historically, this event has been held in person in an auditorium, either at the Washington College of Law or here at Arnold Porter, and typically has drawn between 100 and 200 participants, attendees. This year, however, we have almost 1,000 registrants. So it appears that one of the silver linings of the COVID crisis for us here is that we are reaching a far broader audience today. The virtual format of this session and of so many other events that we are participating in is one of the many adaptations that all of us have had to make on the professional front in response to the crisis. In the field of international arbitration, those of us who are focusing on counsel work have had to reinvent our jobs in many ways in terms of organization of our teams, communications with clients and witnesses, collection of evidence, and how we conduct the hearings. And unfortunately, however, one of the aspects of international arbitration that likely has not changed this year is that of the dirty tricks that Professor Gaillard will be addressing in his lecture today. Since this is a persistent problem in our field, I am especially glad that Professor Gaillard has decided to tackle the issue frontally in this lecture. Although I confess that when I first heard the title of the lecture, my first reaction was, why only 7? Before we introduce Professor Gaillard, whom we are very pleased to have as this year's lecturer, and since this is the 15th anniversary of the lecture, it seems like an appropriate time to recall the many luminaries in the field on a global level in international arbitration who have delivered the lecture down the years. So let me just quickly read off the list of the past lecturers. The first one was in 2006, Jerry Axon. Then we had Julian Liu, Sir Vivian Ramsey, Jan Paulsen, Yves Derans, Gabriel Kaufman-Kohler, the late Johnny Wieder, Bernard Hanatu, Bernardo Cremades, Pierre Tercier, James Crawford, Pierre Mayer, Rusty Park, and Yves Fortier. I'm sure you will all agree that this is quite an all-star cast, and this year is no exception. Professor Gaillard will be introduced formally by Horacio Grigera Naon, who is the director of the Washington College of Law International Commercial Arbitration Program and the leading arbitrator. Before I turn over the floor to Horacio, on behalf of Arnold Porter, I wanted to welcome all of you once again. Thank you for joining us, and I hope that you enjoy the lecture. Horacio?
Thank you very much, Paolo. It is, of course, for me a great pleasure and honor to introduce to you all somebody who's an introduction, of course, Professor Gaillard. When I first met Professor Emmanuel Gaillard in Buenos Aires and at Harvard Law School, none of us had any white hair, which we know now. But since then, Professor Gaillard has had a stellar career in international commercial arbitration and in investment arbitration, both as counsel and as arbitrator. He created the Shearman and Sterling 100 lawyer international arbitration practice. He is the law firm's global head of disputes and global head of the International Arbitration Practice Group. He is also a professor of law in France, and he serves as visiting professor at both Harvard and Yale Law Schools. The universal reputation of Professor Gaillard does not need to be mentioned because it's known to all of you. But I must say that in addition to all his qualities, he is a part of the great French tradition in private international law and international commercial arbitration. His name is associated with Henri Batiffol, Berthold Goldman, and Philippe Fouchard. And that great French tradition in the area of international commercial arbitration has had, and has, of course, a big influence in the development of international commercial arbitration all over the world. Without further ado, I leave you with Professor Gaillard.
Thank you very much, Horacio and Paolo, for this invitation. Tonight or this morning, we discuss only seven dirty tricks to disrupt an arbitration and the responses of international arbitration. In fact, the history of arbitration has been one of constant reaction against attempts by recalcitrant parties to disrupt proceedings in the hope of avoiding being bound by an award rendered on the basis of an arbitration agreement they previously accepted. And it's not a new phenomenon. This is something I had the privilege to debate with the much regretted Johnny Wieder in Stockholm at the ICA Congress in 1990, preventing delay and disruption of arbitration. And the least that one can say is that the state of affairs has not improved since then, and that the imagination of disgruntled or recalcitrant parties seems unlimited. Of course, obstructive behavior is not encountered in every arbitration. It's found at the margins of the system. But if the incidents at the margins of the system are not dealt with appropriately by courts and arbitrators, they will spread and infect the entire field. In that sense, the pathological cases, which are interesting in and of themselves for their pathology, are also a test of how well the system copes with extreme conditions. So it's a test of the resistance of the system. And the topic, of course, lends itself to many anecdotes and war stories that probably explain the number of attendees, but it also illustrates one of the most fundamental methodological debate in arbitration law, the following one. When confronted with attempts to evade the operation of an arbitration agreement, or more generally to disrupt an ongoing arbitration, should arbitrators or courts seek to identify the law applicable to the issue at hand, or should they resort to a different methodology, that of the substantive rules approach, method, des règles matérielles? So do you want to follow a traditional choice of law approach and find the applicable law to the answer, or develop rules which are specifically tailored to respond to a particular arbitration problem? And this is, in my opinion, one of the most fundamental, if not the most fundamental, methodological divide in contemporary arbitration, and it has been for some time. Of course, this debate has some correlation with another fundamental debate in arbitration, that of whether the arbitration phenomenon has given rise to sufficient collective normative activity at a transnational level to be regarded as a genuine legal order, or whether arbitration still has to be viewed exclusively through the lenses of each state in the world with a candidate, which is the law of the seat of arbitration. And of course, those who believe in the existence of a body of norms governing arbitration at the transnational level will be attracted by the methodology that favors substantive rules, whereas those who think that it's okay, it's acceptable to reduce arbitration to a domestic institution in a given country through a choice of law methodology, which after all takes an international phenomenon and says this one is more Lebanese than American. So it's today we will consider that this is a Lebanese internal problem, even if it is completely international. Those who think that way in terms of choice of law will probably not be attracted by the idea that there is a transnational legal order governing arbitration. And I want to reassure you, I will not address this more abstract topic today. I just wanted to flag the connections. And I will focus exclusively on the methodology issue, whether arbitrators and courts confronted with dirty tricks should resort to appropriate substantive rules or should try to classify the matter in one given legal system to find the answer. And following a rough chronological order, I will discuss only, I see some regret in Paolo's voice, but 7 difficult of such attempts in turn, together with the responses developed by international arbitration law. The first trick is old and French, and that's not me. It goes back to the 60s, and here it goes. The underlying contract is void, and as a result, you arbitrators cannot decide the issue without prejudging the matter. Let's go to courts. If I'm right, the underlying contract is void. As a result, the arbitration agreement which it contains is void. And as a result, you cannot decide. We need to go to court. And that, we all know the answer to that. The answer to that is the autonomy of the arbitration agreement or separability of the arbitration agreement. An arbitration agreement is legally independent from the main contract, and the fate of the main contract does not affect it. We all know that. An arbitrator, as a result, can say, yes, the contract is void. It doesn't affect the arbitration agreement it contains, and we are good. Now, precisely because this rule is unanimously accepted, it's a very interesting one from a methodology standpoint. And here I have 3 remarks. One, it is indeed unanimously accepted today, but it has not always been the case. The answer was given first in France, possibly with a precedent in Switzerland. It's Gosset versus Carapelli, a sale of grain contract between a French company and an Italian company. The French company Gosset argued that the contract was simple sale of grain contract required export authorizations which have never been granted. And for that reason, the contract was void, and therefore the arbitration agreement was void. They lose in arbitration. When the award is presented in France for enforcement, they re-argue it and say, look, I discuss your jurisdiction, because if I'm right that the contract is void, then as a result, the arbitration agreement is void. Therefore, you need to listen to me. French court said, no, thank you. This is a problem regarding the substance of the main contract. It has been decided by the arbitrators. It's not my problem, because whatever happens to the main contract is not going to infect the arbitration agreement, which is completely autonomous. That solution has been explained very clearly by the Court of Cassation on May 7, 1963. In England, the same solution was accepted in Harbour versus Kansas 20 years later, 20 years later, so that when English judges have not yet found a solution, nobody should despair. It takes 20 years to reach the same result, generally. I'm joking. And in Harbour versus Kansas, they decided exactly the same thing, same problem. The substantive contract is void. It's a reinsurance contract. The arbitration in London, allegedly void because Kansas has failed to observe certain regulations regarding insurance. And here, Lord Hoffman, exactly like the rapporteur in France, Georges Hollo, did 20 years before. They say it concerns the main contract, does not infect the arbitration agreement, which is independent. Several. Now, today, this rule, this is one of the rare rules which is completely universal. It's in every national legislation. It's in the model law, Article 16(1), second sentence. It's in every arbitration rule. Everybody accepts it. Now, my second remark is, despite the fact that it's accepted universally, it's not an obvious rule. And the nature of the rule, it's a legal fiction. And because it's a fiction, you cannot go to the reality to combat the rule. You cannot say, no, in fact, this arbitration clause is towards the end of the contract, it's Article 26, and it's part of the rest of the contract. And there is a clause in the contract saying that every clause is to be understood together or whatever. You cannot do that. You cannot resort to reality. This is a fiction. This is a legal technique which is used to further a certain goal. The goal is to enable arbitrators to work without this kind of interference. And those who are interested in the topic will read, when it's published, the course Eduardo Silva Romero has dedicated to legal fictions in international arbitration at the Hague Academy in 2019. But my third remark on this, it's unanimous, it's a legal fiction, but it's also a règle matérielle. And it's efficient because it's a règle matérielle. And if you imagine any situation, take a Lebanese seller, a German buyer having an arbitration in Switzerland, and if you were to say, well, one party is saying that the main contract is void, therefore, do I have jurisdiction? Do we have the rule of autonomy of the arbitration agreement? I have to use a choice of law approach. Which law governs? Oh, it may be Lebanese law. Where do I find it in Lebanese law? You may not find it. So the point I want to make here on this simple and accepted example, which will be relevant for more difficult issues later, is that it's effective because it's a règle matérielle which is meant to address substantively a specific arbitration issue. And that would be true for other rules when I come to them. So that's the first trick and the lessons we can draw from it. Now, the second trick, it builds on the lessons of the first one. The second trick is, okay, I understand. I'm the disgruntled party. I won't disrupt the arbitration. I understand I cannot attack the main contract. It's useless. It will go nowhere because the arbitration agreement is independent. Okay, in that case, I will attack the arbitration agreement itself. So it's not the main contract which is void. It's the arbitration agreement. The arbitration agreement is void. It's I didn't understand it. I don't know what the ICC is. It was not signed by the right person. My CFO didn't have the authority to bind the company, whatever, or the subject of the dispute does not fall within the scope of the arbitration clause. Now, this is not an indirect attack, it's a direct attack on the arbitration agreement. And here again, we all know the answer. The answer is the principle of competence-competence, or rather the positive effect of competence, positive in that it's the rule as addressed to the arbitrators. Arbitrators are told, because of this competence rule, when your jurisdiction is at stake, you can continue to work. It's not illogical. You can continue to work. You can decide that you have jurisdiction, or you can even decide that you do not have jurisdiction. And it's not an absurdity to say, I decide in an award that I do not have jurisdiction because the arbitration clause is invalid. It's not an absurdity, but when you think about it, the source of that power cannot be given to you, arbitrator, by the arbitration clause itself. It has to be given to you by a substantive rule of arbitration law, and an objective rule, objective in that it does not depend on the consent of the parties themselves. It's an objective rule of arbitration law. And here again, three remarks. One, it's also virtually unanimously accepted. In France, it was accepted since the Impex case in 1971. It's also found in every modern arbitration law. It's found in the model law at Article 16(1) first sentence. The arbitral tribunal may rule on its own jurisdiction, including any objection with respect to the existence and validity of the arbitration agreement. So that's unanimous. Yet, it may well be the most illogical rule you may find in international arbitration, because it's like, how come arbitrators can decide on their own jurisdiction, or because there is an arbitration agreement, if the arbitration agreement is null and void? And this is a rule which is illogical. That's why in England and in Germany it took time, because they are very logical, very Cartesian, to accept that rule. And in France, because we are very practical, we accepted it more readily. But it's a rule which is an important substantive rule, règle matérielle, of international arbitration, without which every single arbitration could be disrupted, because you could always say, rightly or wrongly, look, I did not consent to this arbitration, and you cannot decide it, because it would be a logical impossibility. I may be right, I may be wrong, but in any event, we need to go to court. And this rule is a fundamental rule, substantive rule, which enables every arbitration to function properly. And you find examples in the case law. For instance, recently, the ICC award number 17,818 of 2019 said that the signature in a contract is forged. As a result, I don't even have jurisdiction, because the arbitration clause is signed by someone who never agreed. It's a forgery. So, but nobody cares today. Nobody says it's just impossible. This is impossible to do that, because that's a technique which is devised by international arbitration law to reach a certain result. So it's a fundamental rule. It's also technically a substantive rule to tackle the second dirty trick. Now, the third dirty trick, it's also built on the lesson of the second one. I cannot disrupt the arbitration agreement by challenging the main contract, that I understand. I cannot even disrupt the arbitration by telling the arbitrators that they cannot proceed because the arbitration agreement is null and void or doesn't cover the substance in dispute, because they will continue anyway. So what I can do is go to court immediately in any event And with a little luck, the courts will decide the issue before the arbitral tribunal. And it may even encourage the arbitral tribunal to stay, because after all, they will say, why bother to decide whether this arbitration agreement is void or not, is the signature forged or not, if someone else, a court, will do it for me in any event. And presumably, at least if it's the court of the seat, it will be binding on me. So why bother? Maybe I should stay. And the answer to that trick is what I have called the negative effect of competence-competence. It's the flip side of the positive effect. The positive effect says to the arbitrators, yes, you can proceed when your jurisdiction is challenged. And the negative effect is, in the meantime, the courts will refrain from deciding the same issue when there is at least a prima facie arbitration agreement. So they look at the contract, they see a prima facie arbitration agreement, and they say, go arbitrate, come back with the result. I will check the award, but I will give you a priority. So it's a rule of priority. And the way it was adopted, if you look at the history of arbitration, is a bit interesting, because when the French wanted to convince a court to adopt the rule of competence-competence, they said it's German, it makes sense, it's very well known in Germany, you can use it. In fact, in Germany, it meant something completely different. It meant competence-competence was not accepted in arbitration, it still is not to a large degree today, but it was meant to say that in some cases, a court can decide finally an issue. You have competence-competence, means you decide and no appeal, nothing, it's final. And when the competence-competence rule was adopted in France, then scholars who knew German law better than the French scholars, like Mann, for instance, in England, said, you're crazy. You don't want to give the arbitrators that power, because they need to be to be controlled by a court later. It cannot be competence-competence. It cannot be final. And now the case law evolved, and people understood that what was meant by competence-competence and the negative effect was simply a rule of priority. Arbitrators can decide on their own jurisdiction, pending that courts would refrain from doing so, because if not, it will really take back what was given by the positive effect of competence-competence, if at the same time you allow courts to do the same job. And that is nowadays pretty well understood. So the rationale of the principle is that it makes little sense to accept, which is unanimously accepted pretty much in the world, to give to the arbitrators the power to decide on their own jurisdiction, if at the same time you let courts do the same thing, and presumably their decision will prevail. So that's the rationale. The rationale has been very well expressed in 2015 by the Singapore Court of Appeals in Tomolungen. The court said that to require the court to undertake a full determination of an arbitral tribunal's jurisdiction, as opposed to a prima facie one, could significantly hollow the competence-competence principle of its practical effect. The full merits approach has the potential to reduce an arbitral tribunal's competence-competence to a contingency dependent on the strategic choices of the claimant in a putative arbitration. That is very well put by the courts in Singapore, which have embraced that principle wholeheartedly. Now, this is still not, unlike the first two principles, this principle, the negative effect of competence-competence, is still not accepted unanimously. It has made, however, tremendous progress in the past years. It's accepted in many Latin American countries, Venezuela, the Supreme Court, Colombia. It made some progress in Argentina and Brazil. In Africa, it's recognized in the OEDA Uniform Act, in Tunisia, in Morocco, in Mauritius. Mauritius has very good case law on this. In Asia, what matters is that the two most active centers, which are Hong Kong first and Singapore, as we have seen, have endorsed it. Also, the Philippines. In Europe, France took the lead, as I mentioned. Switzerland accepts it in some circumstances, but it does not mean that it's universally accepted. Germany which is not very pro-arbitration in many respects, went out of its way to modify the model law, which it otherwise accepted, to exclude in Article 1032 of the ZPO the competence rule, saying that prior to the constitution of the arbitral tribunal, an application may be made to the court to declare whether the arbitration agreement is valid, which is a way to torpedo the arbitration, the negative effect of competence. And in the US, the case law is so complicated, it does not accept competence, but it accepts a certain form of competence in first option sunshine. And I have no time to discuss the niceties of the US case law on this, which is not yet completely stable anyway. But to me today, this is probably the acid test of the favor to arbitration, which any local law, any legal system can have. And it's a bit sad that in Switzerland they are still dancing around this principle, and they recognize it only when the seat is in Switzerland, not when the seat is elsewhere. But now modernity is in Asia, and it's on the other hand very comforting that both Hong Kong and Singapore have endorsed the principle wholeheartedly. So modernity in arbitration is sliding towards the east, as we can see, but Latin America is fighting hard to keep a good law on arbitration. So now let's talk about dirty trick number 4. Dirty trick number 4, since we are doing a lot of comparative law here, is essentially Iranian. What I mean is that the case law on dirty trick number 4 has been mostly generated by Article 139 of the Iranian Constitution of 1979. Admittedly, Syria, Venezuela, Egypt follow suit. And dirty trick number 4 goes as follows. I am a state-owned entity. I signed a contract with an arbitration agreement in it, but sorry, it has not been approved by the parliament in Iran or by the proper relevant minister in other countries. So sorry, I cannot arbitrate, it's null and void. So in Iran, it's the parliament which is required to approve an arbitration agreement for public entities. It's Article 139 of the Constitution. In Syria, it's Public Procurement Law of 2019. You have a similar rule in Venezuela of 1998. Now, the answer which has been developed in the most pro-arbitration countries is found in a rule according to which a state or a state entity cannot rely on its domestic legislation to evade an arbitration agreement it has freely accepted. And you find this rule in Switzerland, which is overall very favorable to arbitration. It's Article 177(2) of the Private International Law Statute of 1987. You find it in Spain since 2003. It's Article 2.2 of the Spanish Arbitration Act. You have it in France. It's the Gatoil case law, and it's constant case law in the Netherlands. The Supreme Court accepted it in 2005 in Iranian Ministry of Defense versus IMS. And by the way, for those who like history, it's also a rule which is found in the European Geneva Convention of 1961 at Article 16(1), which was very modern for the time. So here I have two remarks from a methodology standpoint. Here again, we are talking about a substantive rule, a règle matérielle, that shields arbitration from disruption. You don't look at what is the applicable law to this problem. If you were to do that, you would say, well, it's probably Iranian law in this case, it's Venezuelan law in this case. And in fact, the answer is found not in any applicable law, it's found in a substantive rule, règle matérielle, which says in international trade, this is not acceptable. This restriction shouldn't be given effect. So here it does take a règle matérielle, and it's interesting that as early as 1961, the drafters of the European Convention accepted that principle. Now, the second thing I'd like to say about that is that in France, this rule have been absorbed into another one, even more favorable to arbitration, which is the principle of validity of the arbitration agreement. What it means is that French courts, when confronted with arguments about the effectiveness of any arbitration agreement, will apply the principle, the règle matérielle of validity of the arbitration agreement. They will not look at the applicable law. They will say an arbitration agreement is valid, period. I'm not looking at any applicable law. I'm just looking at sheer consent. If the consent is there, the arbitration agreement is valid. They look only at the consent. This is why, for example, in a decision of May 2019 concerning EGPC, Egyptian General Petroleum Company, the Paris Court of Appeals dismissed outright the argument of one of EGPC, according to which pursuant to its applicable law, the arbitration agreement had to be approved by the Minister of Petroleum. They say in France, it may be true in the Egyptian legal order. As far as I'm concerned, the principle of the validity of the arbitration agreement means that I don't look at any other law. I just look at the sheer consent given by the parties, and that's it. And that even absorbs the previous rule of the rule which looks at which says that you accept that state-owned entities have to can accept international agreements. So it goes even further, and I'll come back to that in a moment. But for now, I will move to dirty trick number 5, which is a bit more aggressive. In light of all of these pro-arbitration developments, some parties take a more aggressive stance. And they say, guess what? You may have competence, you may have autonomy, you may have all these niceties, but a court, generally in my own country, at my request, has enjoined you, arbitrators, and the parties from proceeding, either because there is no valid arbitration agreement or because the arbitrators allegedly have done something wrong. You are biased. I can see your refusal to give an extension of time is a clear proof of bias. Therefore, me, the court, am enjoining you from proceeding, the parties and the arbitrators, and I impose penalties. And it's hard to give a nationality tag to this trick because, frankly, it's now quite widespread. Originally, the mechanism of anti-suit injunction, because this is anti-arbitration injunction, anti-suit injunction is borrowed from the common law tradition, but now it has been gladly endorsed by civil law countries. As a result, you find such injunctions in civil law countries like India, Pakistan, Bangladesh, Nigeria, but you also find it in civil law countries where the judges have found that it's a great idea. I can stop an arbitration which is damaging to one of my national champions. You find it in Indonesia, in Brazil, in Mexico in particular. And it can be extraordinarily disruptive because at least the local arbitrator may feel that even if the injunction is unfair, they have no option but to withdraw or to accept the anti-arbitration injunction. They can face penalties. It's very difficult to resist if you have a house in the country, even if you think that it's unfair and a dirty trick. So it's quite a difficult situation to cope with, and it's now spreading. What is the appropriate answer to an anti-arbitration injunction? Well, it's simply to ignore it and proceed. And arbitration institutions who are not naive have developed rules to replace arbitrators resigning after such attempts. And the fact that the institution can appoint itself the replacement arbitrator when an arbitrator is forced to resign, possibly after this kind of injunction, is very healthy. You find the rule in Article 15.4, for example, of the ICC rules. Now, the case law has also evolved and sometimes accepts that truncated tribunals can proceed in certain circumstances, which can be an answer to anti-arbitration injunctions. But generally, the answer legally is that the arbitrators themselves can and should assess their own jurisdiction, and that the issue raised by the recalcitrant party is assessed by the arbitrators themselves. They don't have to delegate that power to the courts. They have to look for themselves whether the objection to their jurisdiction is founded or not. And the case law provides many examples, because this phenomenon is spreading, of cases saying, okay, you enjoin me to stop, but I will assess my own jurisdiction. And if I think you are wrong, or if you say I'm biased, you say I've done something wrong, but it's not correct, I'm going to continue. A good example is an award rendered on April 10, 2015 by a tribunal chaired by Juan Fernandez Armesto with Eduardo Zuleta and Fernando Salazar under the rules of the Inter-American Commission of Commercial Arbitration. It was an arbitration in Bolivia between a Bolivian company and a Mexican company, and the latter obtains an order in Mexico requesting the arbitrators to stop their activity. And they the tribunal says in very good formulas, the arbitration tribunal has the utmost respect for the ordinary courts of justice, including, needless to say, the courts of Chihuahua. However, the agreement of the parties, the place of arbitration is the municipality of La Paz, Bolivia, and the applicable law is Bolivian law. The Chihuahua judge clearly lacks the jurisdiction to interfere in this arbitration and to issue the provisional suspension of the proceeding in audita parte. And they continue in saying, these conclusions are supported by the most highly respected international legal theory, thank you, which states that the arbitration may continue despite anti-arbitration injunctions. So that's a reaction, and that's the good reaction, the utmost respect, but no thank you, I can decide for myself. And here we see that, by the way, if we had to have a proof that theory is practical, this would be probably the best example, because it's on the basis of legal thinking that you can say what is the source of the powers of the arbitral tribunal. I can decide for myself, no thank you, with the utmost respect. You cannot interfere that easily in the arbitral proceedings. Now, what's a bit more difficult, and that's to me the acid test of the system, is when the order is rendered by the courts of the seat of the arbitration. And I find it perfectly normal that arbitrations are conducted in every country and not just in Paris, Geneva, or London. That's absolutely normal, and that's the trend, and that should be encouraged. At the same time, it does not necessarily mean that one has to accept the local decisions which are used to interfere in the arbitral process and to gain leverage when you have secured a seat with courts which are ready to help one of the parties, especially when it is a powerful party, a state entity, or sometimes a party having the means to convince judges in a certain way. And that's the situation where you have, when you have an anti-arbitration injunction at the seat of the arbitration, should the arbitrators accept and just stop, relinquish their authority and accept the decision, even if they know full well that it's unfair and it's a dirty trick? And to me, the answer is no. And that's what unanimously the Salini Ethiopia tribunal said. I was in this tribunal with Piero Bernardini and Neil Bunny. And we rendered an award, we were all in agreement. We rendered an award on June 30, 2009. I was chairing the tribunal. It was an Ethiopian case. The seat was in Ethiopia, which is great. It should be in Ethiopia. Why should it be in Paris and Geneva all the time, or Singapore these days? It's normal. At the same time, when the Ethiopian courts are, or when one party is trying to abuse the system by resorting to Ethiopian courts to disrupt the arbitration, the arbitral tribunal should resist and should issue an award, and then this award will live its life and will be enforced or not in different jurisdictions. But it would be a denial of justice to not render an award. And this is why we decided unanimously to render an award, and then parties can do what they want with it. If the local courts want to annul the award, they can. If other courts want to enforce it nonetheless, they can. It's no longer the tribunal's problem. But if you give up just because the local court says that you have to. You do not offer to the parties such an opportunity. And by the way, the case afterwards settled, and it would never have settled if we had said, okay, too bad, you have accepted to arbitrate in Ethiopia. Next time you shouldn't do that. Come back to London, come back to Geneva. It's much better, or Paris, you will avoid that. I don't like this reaction because I don't think the reaction should be like in the good old days, you should arbitrate only in Paris, London, or Geneva. It's good to arbitrate everywhere, but it's not a real sign of respect to say that whatever is decided locally will be binding on the arbitrators when you're full blast that it's not serious. And here we were enjoined because we decided to hear a witness not in Ethiopia, pursuant to a rule which was accepted by everybody in the terms of reference. Now, the situation is rare. You also have case law, which is extremely interesting in Nigeria, because Nigeria says, yes, I can arbitrate, or the state-owned companies, especially in the oil and gas sector. Oil companies you can arbitrate in Nigeria. You can arbitrate, but it has to be in Nigeria. And of course, it's tempting when you lose and you're a big local player to go to the local courts and try to have an anti-suit injunction to stop the arbitration. It's extremely tempting. And there is case law, which unfortunately is not public, and you have decisions by tribunals, one chaired by Neil Kaplan, saying exactly what we said in Salini. Fine, there is an anti-arbitration injunction, but at the seat, but we are nevertheless going to proceed. And then what will happen to the award will happen to the award. At least you give a chance to decide, and then the award will live its life, or its difficult life possibly. But if you do not accept to render an award, then you deprive one party from even the possibility to discuss that this award should be respected in certain jurisdiction. And certainly that's an answer to dirty trick number 5. Now, dirty trick number 6 can be called, it's a bit more sophisticated, and it can be called, it's not me. It covers all the situations in which a party to an arbitration agreement enrolls friends, shareholders, affiliated companies, parent companies, even employees, to disrupt the arbitration. They know that if they disrupt the arbitration themselves, they might be caught. And then the tribunal said, no, thank you, I understand what you're trying to do, and I'm going to proceed. So you have someone else do it. It's, if I were to give a nationality tag to this dirty trick, I would say it's Americano-Russian. You find it in the US, you find it in Russia, not exclusively. So it's an attempt to capitalize on the privity of the arbitration agreement, to use parties who are not technically bound by the arbitration agreement to torpedo the arbitration agreement or to hijack it. You have a few examples in the US. So you see, for example, the parent company of a US company involved, or French company involved in an arbitration agreement with another company, suing the parent company of one of the litigants, party to the arbitration agreement, is suing the parent company of the other party to the arbitration agreement for a dispute which at its core is between the two subsidiaries. So it's not, the dispute should be between the two subsidiaries in good faith, but the parent of one sues the parent of the other. for tortious interference or any legal theory, you know, saying, well, the two parties signatories of the arbitration agreement are clearly bound by the arbitration agreement, but I am not, and I can sue someone who is not either. So that's an issue of non-signatory suing a non-signatory. And you can always dress up, or often, not always, but often dress up your contract claim into a tortious interference. So you sue for tortious interference in the performance of the contract. So you dress up a claim which is not exactly a contract claim under the terms of the contract, but you call it something else, and then you sue in court. For instance, you can say it's appropriation of trade secrets, the secrets which were developed in the, say, in the joint venture. And it's a nightmare, frankly, to get out of the court system in the US. You can get a discretionary stay, but when it's a non-signatory, it's hard enough. When it's two non-signatories, even if the core dispute is between the signatories for the functioning of a joint venture, for instance, it's very difficult. Courts have a lot of discretion and should not be naive in this respect. Now, in Russia, that's why it's an American or Russian trick in my book. In Russia, the tactic is facilitated by a rule pursuant to which a party that has a legally protected interest can file a claim to nullify a transaction. So if you have an interest, you may not be a party to that transaction. It's Article 166.3 of the Russian Civil Code. You're an interested party, and you can file a lawsuit to have this transaction, to which you are not a party, nullified. So this is a fantastic tool for litigants who want to avoid the effect of an arbitration agreement, because of course the arbitration agreement will be in the contract itself. But if a party, an interested party, can go to court to nullify this agreement, which contains an arbitration agreement, and is not bound technically by the arbitration agreement, it's a wonderful way of hijacking arbitrations. And that's found in Russia a lot. So all you need to do is to find, if you want to disrupt an arbitration you're a party to, is ask, collude with one of your shareholders or your parent company or even an employee or any interested party to convince them, but the parent company will be happy to be easily convinced, for instance, to sue in court and say, I'm not bound by the arbitration agreement. Nevertheless, what I'm requesting is the nullity of this arbitration agreement, of this contract to which I'm not a party, but because I have a legally protected interest. And this happened, for instance, in one of the UCOS cases, one of the ancillary UCOS cases, where Rosneft was rushing to courts to help one of its newly acquired, by newly acquired, it's a euphemism for stolen, but that's another story, a newly acquired subsidiary who had to respect an arbitration agreement. And Rosneft was saying, yes, but I have a legally protected interest to nullify the transaction. And then, even if the arbitral tribunal has obviously jurisdiction to decide on this contract, this maneuver creates a precedent, which is not a theoretical precedent, it's a precedent on point. And if the contract is governed by Russian law, it will be very difficult for the arbitral tribunal, looking at a decision which says under Russian law, this contract is null, as I have decided at the request of the parent company of the litigant, And it would be very difficult for the arbitral tribunal to say, no, I'm sorry, it's wrong. I know Russian law better than Russian courts. So that's why this is a dirty trick, which is quite difficult to cope with, but vis-a-vis which the arbitrators certainly shouldn't be naive. And generally speaking, arbitral naivety is not to be commended. You will see the case of Moravel versus Jugens Neftegas, an award of April 2007 to that effect. So what should be the response of international arbitration law when confronted to this type of trick? Well, I think just like we have seen the development of substantive rules, autonomy of the arbitration agreement, competence-competence, negative effect of competence-competence, ineffectiveness of anti-suit injunctions, and the like, I think here the response is in development, and I would welcome the adoption of new substantive rules, which would be based on a set of criteria which have been this time, which could be this time borrowed from a case law developed by English courts when they cope with collusion allegations. Because in a case like this, what's difficult is to prove the collusion, because you have one party and it's another party trying to disrupt the arbitration agreement through a legal theory which exists in the country. So it's very difficult to cope with that. And the English courts have developed a set of criteria to cope with this type of attitude. And the test under English law, which I would like to see adopted more generally by the arbitral community, is that if you have between several parties commonality of interest or common control, and you see suspicious timing, and that's a very interesting test, you see commonality, these two parties have the same interest. One is bound by the arbitration agreement, not the other, but they have commonality of interest. One is the parent of the other, one is a big shareholder, whatever. Commonality of interest and suspicious timing. And the beauty of that rule, which has been developed in England, is that suspicious timing is a proxy for I have the proof that they colluded. Because the proof that they colluded, you will never get. Even if you have a document production, they will not give it to you. They will say it doesn't exist. So the proof of collusion will be very, very hard to establish. What you can establish, it's a proxy for the proof of collusion, which is suspicious timing. And that's, you find that in the English case law. For instance, the Court of Appeals in BNP Paribas, that's a Russian case, in 2012, has used this test. Now, this test has also been used by arbitrators. And for instance, in the LCIA case number 142,730, an award was rendered in October 2017 by Doug Jones, sole arbitrator, in a situation in which a party used the parent to sue locally to undo what had been promised by the subsidiary. So the subsidiary can say, well, it's not me, it's my parent, but you have no jurisdiction on my parent. And you see this test developing. If the timing is suspicious, it's a proxy for you have colluded, which is just impossible to prove. So if you have a commonality of interest, it's your parent or it's a party which has the same interest as yours, and the timing is suspicious, it's good enough. So I would like that specific English rule to become one day a new principle of international arbitration, because I bet you that this kind of trick, which is to use an affiliated party, a friend, to do what you cannot do yourself, will develop. Now, the few minutes left, I will devote them to dirty trick number 7. I have started with an old French trick, and I will finish with a new, young Swiss trick. And I'm not talking about Sébastien Besson, although it would be fun. You will understand what I'm talking about. Now, the trick goes as follows. An arbitration agreement, guess what, is a duration contract within the contrat de durée, within the meaning of Swiss law. And as any duration contract, a contract which develops over time, it can be terminated for just cause, juste motif. And if it means that if a party cannot legitimately be required to arbitrate in the circumstances, guess what? This is very, very vague. And Swiss law, which so far was probably the most, with French law, the most pro-arbitration legal system, is at risk of being polluted by this rule. Now, under Swiss law, duration contracts can be terminated for just cause. If it's a long-term contract, it can be terminated for just cause. The federal tribunal extended the rules from different contrats spéciaux, different specific contracts, and to extended to every duration contract. So the rule is found in certain contracts, but it has been extended to all duration contracts. Now the question is, when the arbitration agreement is governed by Swiss law, can a party say that it is a duration contract, and therefore, like every duration contract, it can be terminated for just cause? And unfortunately, today, the majority, not everybody, but the majority of Swiss authorities have said yes. This came from the German-speaking side of the doctrine in Switzerland. Werner Wenger, Goxu, Oetiker, but also Gabriel Kaufmann and Rigozzi, Nathalie Voser. Pierre Carrère says it's wrong, but he's in a minority. So at the moment, you have no case law in Switzerland, but you have a broad body of authorities saying an arbitration agreement is or can be a duration contract. If it is a duration contract, it can be terminated for just cause. Of course, I perfectly understand that it's not going to have to happen often. It's not going to be often the case that a tribunal having jurisdiction, fortunately, to rule on its own jurisdiction, will decide that yes, there is a just cause and I can terminate the arbitration agreement. The idea clearly comes from Germany, where the case law there is established, and you have case law from the Supreme Court in the 80s and the 90s saying, yes, arbitration is a contrat de durée, it's a duration contract, can be terminated for just cause. But the fact that German law is not that favorable to arbitration is no news. The fact that Swiss law becomes not favorable to arbitration would be major news. And I say that if this notion is accepted under Swiss law, it will become a new danger, to speak like Mann, like Francis Mann, a new danger for arbitration in Switzerland. Now, the test for just cause is purposely vague. It's to avoid a party to be the prisoner of a contract. And it's not good enough, I say, to suggest that it will seldom be accepted by arbitrators or even by courts. The fact that it's not accepted doesn't mean that it's not a bad thing. because it will give rise to litigation. And it not necessarily just at the beginning, it can be in the middle of an arbitration. I think you've done something really bad. You've not respected the document production rules in a way which is really shocking. So I don't trust the system anymore. I have a just cause to terminate the arbitration agreement. Here is my termination notice. And the arbitral tribunal, possibly, I've seen that in a case, would stop and think about it. It takes a year, it costs you several $1 million to dispute it. And at the end of the day, you prevail. Ah, yeah, but the other party was able to stop the arbitration proceedings for 2 years or 1 year and several months. So that would be a huge deterrent to arbitration in Switzerland, and there is no case law at the federal tribunal level. I think that the Swiss community has to act and add a provision in the private law and private international law statute to state expressly that this does not apply to international arbitration. So it also shows, by the way, from a theoretical standpoint, the shortcomings of the choice of law approach, because if you look at the arbitration, if you look at the law applicable to the arbitration agreement in the pure choice of law approach, you may find a law which is not so favorable, and you may find a law which says, yes, a breach of the arbitration agreement until its termination for breach, because it's a regular contract. After all, you know, if a contract is breached, one party can declare that it terminates the contract. And for an arbitration agreement, it's exactly the same. So that's why the contrast is huge with the rule which has been adopted in France since 1972 in the case law. It's the rule of the validity of the arbitration agreement. I said I would come back to it. Since 1992, this rule says courts will look at consent only for arbitration agreement. They will not look at the applicable law. They will not look at anything but the raw consent. And sometimes this is a rule which is difficult to understand, although it is the simplest. It may be difficult to understand for lawyers precisely because it's too simple, but it means you don't look at the ordinary law of contracts, you just look at the arbitration agreement, you look at consent. If there is consent, it's good enough, end of story. And certainly when you contrast that with an approach that, oh, yes, but Swiss law is applicable to the arbitration agreement. In Swiss law, duration contracts can be terminated for just cause. Here, I don't trust you. You've cheated on the document production. Therefore, there is a just cause, and let's discuss it. I may be wrong, but let's spend a year discussing it with the arbitral tribunal. That's a bad rule, and it shows by contrast that the rule of the validity of the arbitration agreement is really good. And that's interesting because France and Switzerland have probably two laws which are very similar in many respects, which are very favorable to arbitration. But if this bad rule develops in Switzerland, it's a danger. It's to speak like Francis Mann, it would be a new danger for arbitration in Switzerland. So I'm done, but by way of conclusion, I would like to say the following. In case I've been too subtle so far, I have to disclose in the interest of transparency that my own preference goes for the substantive rules methodology and not for the choice of law methodology, in case some of you would not have got that before. Thank you very much. Thank you for your patience.
Thank you so much, Professor Gaillard, for a very thought-provoking presentation, full of references to comparative law, which is always a contribution to the knowledge of all of us. You are really a star because we have over 1,000 people watching you. And this, of course, creates a problem. We always open up the floor for questions, but this is a floor that is out of any possible organization on from our perspective. So we have decided, maybe arbitrarily, but to continue enjoying your knowledge of these issues, to limit ourselves to 4 questions. 2 will be put to you by Paolo Di Rosa, and the other 2 by me. So if Paolo is ready, I would invite him to be the first.
Thank you, Professor Gaillard. Can you hear me?
Yes, I can hear you well.
Yes, thank you for your excellent presentation, very thought-provoking, as Horacio pointed out. My question is the following. All of these dirty tricks that you are referring to are essentially attacks on the arbitration system, right? And they are essentially consist of efforts by people to exploit flaws that are inherent in any private system of dispute resolution. And you alluded to the fact, for example, that the doctrines of separability of arbitration clauses and competence-competence are not necessarily obvious, and they have certain conceptual flaws. And I think that's quite right. You know, these are doctrines that were adopted essentially as mechanisms or fictions, to use your term, to be able to get around these problems that would otherwise essentially vitiate arbitration as a mechanism for dispute resolution. Some of the later tricks that you referred to are issues that are not quite, the solution to which are not quite universally accepted, as you pointed out. So my question is this: I mean, you could see the various solutions that are being developed to these different problems as evolutionary adaptations, right? To be able to resolve these problems that are inherent to this system in circumstances where the system is sort of necessary, right? You know, this is why we're finding these evolutionary adaptations. So my question to you is, based on your long experience in this field, and in light of everything that's going on in the world in terms of international commerce and you know, rules that are developing in different countries governing these issues, do you see a greater likelihood that the evolutionary adaptations will continue in such a way as to grant progressively greater legitimacy to arbitration as a dispute system? Or do you see these problems becoming more intractable over time? Because, you know, essentially there are two options. You either stop evolving and you become extinct, or you adapt and you progress. So I was just curious about your thoughts on these larger picture issues.
That's obviously a very good question. And this is why I wanted to be more or less chronological. I wanted to take the questions from a historical standpoint, starting from rules which are very well established, almost universally established, and then rules which are just developing, simply to show that, that it takes time to have an answer. And when you look at the first rules, which are completely established, autonomy, you know, take competence, even if it's in its positive effect, which leads to the situation where arbitrators can say, yes, the arbitration agreement is void, I still render an award. You would think that if you were the first one to think about this for the first time, especially in today's environment, you may say, well, no, it's a logical flaw. You know, how can you say this piece of paper on which I write the award doesn't exist because I don't exist, because there is no consent. Nowadays, it's completely accepted that we can do that as arbitrators, but it's not natural. And that's why I took a historical stance, because I think that new rules, it takes time, but new answers will be given to new tricks. And frankly, I personally do not think that it's a sign of respect to say to a party in your country, no, thank you very much, but I'm not convinced that that you're right. You are trying, of course, you're trying to disrupt the arbitration, but no, thank you, I'm still going to render an award. I don't think it's a sign of respect. And what makes things difficult is that people may like it or not, but arbitration will take place. It will be scattered around. It's not going to be, and it's not today, but even less tomorrow, going to be only in a few centers. And one answer can be, if you don't like to arbitrate in Ethiopia, you see you've been burned, come arbitrate it, come back to Geneva. I don't think it's the right answer. I think it's legitimate to arbitrate in Ethiopia. At the same time, you could say to the Ethiopian consul, who may happen to be an American, by the way, no, thank you. I see what you are doing, and I don't accept it. You're trying to abuse the system and the court system, which is a good try, but thank you, no, thank you. So I don't think it's respecting a country, even if the country, of course, is trying to portray that as, you know, you don't respect me if you say no, thank you to my judge. Say, well, I think you respect the country more if you say I can see through it. It's an attempt, well done, but no, thank you. So I think it takes time. I think it's a progressive development issue, and that's why it's really important to go back and look at history and how these rules were developed, because it does take time. It's not natural. It may be a fiction for some of them. It may be counterintuitive, but it's the necessity of the protection of the system which calls for certain answers. So that would be my answer. So I'm hopeful in the system, and I certainly don't want to go back to, next time you'll come back to Geneva. I don't believe in that. It's not going to happen anyway, and frankly, it's not the legitimate answer. It's good to have arbitration everywhere. It doesn't mean you have to be naive, and if someone finds a nice judge, especially a state-owned entity, how can the local judge resist the pressure of a state-owned entity or the state itself? They can't. At the same time, if they want to arbitrate in all countries and in their country, fine, that's a progress. So that would be my answer. So I'm hopeful.
Okay, then it's my turn. Obviously, the issues that have been raised by Paolo that were present throughout your presentation is an issue of the sources of the law. You are referring to material or substantive legal rules that would be applied instead of the conflict of law system, whatever that system would be. But how far are we advanced in that respect when we have to address certain specific problems that are present in actual arbitrations? And what I have in mind are two problems. One of them is document production, and the other one is the issue of privilege. In terms of document production, it is not unusual to see in procedural orders a reference to the IBA rules on the taking of evidence. But if you look at the IBA rules of the taking of evidence, there is no reference to burden of proof. And however, in cases, we see oftentimes the issue that arises when one is analyzing the different position of the parties, that one party is saying, why should that document be produced? It's the burden of proof of the party that is requesting that document to honor that burden of proof. And the other approach is to say burden of proof has no reason to be a matter of consideration because any party has the right to explore what is the evidentiary support of the submission of the opposing party. And of course, if you are talking about issues of burden of proof, you may have issues of applicable law. How do you determine who has the burden of proof? So that's one issue that you may have some thoughts. And the other issue is, of course, the issue of privilege. What law governs privilege? What law tells me what privilege may be invoked in order to object to a request for production of documents? Are we talking about attorney-client and work product, as it is normally accepted in the US and in England, or not, or something else should be done? So let me pick your brain on these two, if you would like to address them.
Yes, well, obviously there are two very good questions and difficult ones. I think both examples make the case for a transnational approach, because you have a paramount rule, which is equality of the parties, and if you apply the choice of law methodology to any of these rules, you will end up with surprises and inequality. To start with the privilege, which probably is the easiest for me to answer, and it's one thing which is not well developed, so there's still issues. We see that routinely. If you apply a choice of law approach, you are probably going to have different rules applying to different lawyers, and maybe a company lawyer in the US will be protected, and the same, the analogous company lawyer in Europe will not be, or say continental Europe will not be protected by the privilege. So, but you have an overarching principle of equality of the parties. So a tribunal will be extremely reluctant to say, well, you French lawyer, you the general counsel of Total, please give me all of your documentation. But the general counsel of Exxon has the privilege, and they don't have, in an Exxon Total dispute, to disclose anything. So the overarching interest of equality of the parties will really call for a transnational solution, because if you use a choice of law solution, you may say, yeah, the general counsel of Exxon doesn't have to give anything, but the general counsel of Total does. But as an arbitrator, I cannot accept that. So it makes the case for the progressive development of a transnational solution. In document production, the IBA rules have achieved that. And yes, there may be lacunas, and for instance, the burden of proof may be something which arbitrators still have to resolve. But I'm certainly, for myself, do not think that they could insert a choice of law approach into something which is overall covered by a transnational set of rules, very well accepted via IBA rules. So they have to develop, in the spirit of the rules, how to tackle the lacunas which may be found. And you give two examples which are very, very relevant in these transnational rules, but in the same spirit, because if not, you may create two things: inequality of the parties. So you cannot say, well, you have a privilege, but you Exxon general counsel, you do have a privilege, but Total's general counsel does not. So that's not acceptable. And oddities or surprises. If you follow the choice of law approach in the gaps of the well-accepted transnational rules, I think you should supplement them in the same spirit. That certainly would be my answer. But I accept completely that you have picked really two examples which are still subject to debate and difficult.
Paolo?
Paolo, you're on mute. Unless I'm mistaken, you're on mute, Paolo.
Yes, he's on mute. Have you lost you, Paolo? We cannot lose you at this very...
Can you hear me now?
Yes.
I have an echo.
Yes, you have an echo.
Because one of your devices is muted.
Let me mute mine.
There we go.
Good.
Thank you. So Professor Gaillard, we're running short on time, but I have what I hope is a narrower question for you. And it's going back to your fifth dirty trick, which was the anti-arbitration suit injunctions. And with respect to this, I had a couple of questions. One is, you said, well, one of the answers or solutions to these anti-arbitration injunctions is for the tribunal simply to go forward, issue its award, and then whatever happens to the award happens. There are two issues that I have with that. One is, obviously with the party that filed for the injunction is going to then run back to the court that issued the injunction and say, these arbitrators are flouting your injunction, they're in contempt, essentially, and the court could, in fact, issue a contempt order, which would then expose the arbitrators to personal liability. So, how do we get around that problem is one question. And the other question is, aren't the various solutions that you identified somewhat in contradiction with the agreement of the parties to accept the substantive law that in fact enables these types of injunctions? So those are my two questions relating to the fifth dirty trick.
Right, of course, two very, very good questions. On the first one, I think that it's a responsibility of the arbitrators to find the right solution, even if they have to overcome the local injunction. And I don't think it's disrespecting the system, the local system, to say, well, in that case, I will still render an award, and you may do whatever you want with it. Because if you do not render an award, the award cannot be recognized anywhere. And you let one legal system hijack the system. And now you have at least two theories to recognize awards which are annulled at the seat. You have the French theory, which is, I look at it for myself. I don't pay attention to any other decision because the award is above the legal systems. It's not in a legal system. And you have the American theory saying, I can in certain circumstances, disregard the annulment because the annulment itself is against international public policy or unfair or whatever. So it's two different methodologies. But if you let a party hijack the system and prevent the rendering of an award, you don't even get to that point. And maybe the conditions of the American case law or the French case law, which are easier to fulfill, are fulfilled. So I think if you are the arbitrator, if you see something which is clearly tactical, you have, of course, you don't want to antagonize the local laws on purpose, and if you can render the same decision within the concepts and the parameters of the local legal system, you are happy to do it. But when it comes to the hard case where there's a clear conflict, I have an anti-suit injunction saying that I should stop. Do I stop or not? I know that there are practical issues. You may not go to the country for some time. If you're a resident to the country or your wife is from that country, you have to give up. And that's completely understood. But I think it's doing a disservice to the system to give up prematurely. I think the responsible answer is to render an award, which is a private decision, and then whoever will do whatever it wants with it. If one party wants to get it annulled locally, fine. If another system wants to say, I still recognize it because US style, it's against international public policy, it's for a bad reason that you decided that, or because French style, because I don't look at decisions about the award, I look just at the award itself. It's at least you have to create, there are a sufficient number of countries which accept that annulled award, they differ on the conditions, but they accept that annulled award can be enforced to give them a chance. When you're an arbitrator, you say, I have to give them a chance. They may annul me locally, they may not recognize me in certain countries, that's fine, but I have to give them a chance. If you accept that you don't even go as far as rendering an award, then you reward one party and you don't give any legal system a chance to decide whether it's fair or not. So that would be my answer to that.
Do I have the time for my last question? Paolo. Okay, he's silent, so I'm going to put my question to you. Well, the issue here, at the end of the day, to a certain extent, is the interaction between what happens within the four corners of the arbitration and what happens when the arbitral proceedings gets in touch with the outer world, which are the world of the courts of law. And I'm going to refer to something that should be familiar to you, and it is the model law version adopted by Egypt. And this is a problem with homogeneity at the level of the legal systems. Under the model law as adopted by Egypt, there is the possibility to review the applicable law. And an award might be set aside, not just because of procedural defects, due process, but also by questions regarding the applicable law. You were one of the arbitrators in the Chromalloy case. Robert Briner was the chairman. You were one of the co-arbs. And if you could illustrate these issues from your experience in Chromalloy, which also, as you know, the award was under the same rules that you are referring to, was brought for enforcement in the USA, although annulled in the country of the seat, without betraying le secret du délibéré. Could you give us some insights of the reasoning of the tribunal and how you got to that decision?
Well, that will be very easy because, in fact, the argument which was raised before the court to annul the award was never raised before the arbitral tribunal itself. It's an afterthought, and that's an archetypal example of why, you know, state-owned entities, here it's the army, they have some leverage in Egypt, as we may gather, and can a judge seized with a request from the army to say this award is not good, you have to annul it, do you think they have a choice? I personally think they don't. That's why I think it would be a mistake to give a transnational effect to that decision automatically. I think that the French solution, which said, no, I have a second look at it. This judge thinks that, but I'm a different judge. And as far as, and it's not imperialistic because it's just to say, as far as recognition is in France is concerned, I may still consider this award. And personally, I think a judge has no chance, has no option to decide against the army in any country, in most countries. And why should we give an international effect to that? Maybe it's a lesson to say, next time you'll arbitrate in London or Paris, like in the good old days, but these good old days are not going to come back. And I don't see why we should always arbitrate in Paris or London or Geneva because it's pro-arbitration. But at the same time, I don't see why we should abdicate any control to the local courts, and we know that the local courts in many situations have zero option. It's not doing a service to the system. Now, I prefer the French system, which says, I don't look at it, period. I look at the award only, than the American system, which is I look at the award and I look at the decision about the award, and if the decision about the award is not good because it's flawed, because it's partial or what, I revive the award. I don't like it because it makes a distinction between bias well dressed up and bias poorly dressed up, and I don't think it should be the distinction. The distinction is, by definition, you are the local courts, you have a certain bias, and your decision has no reach in other countries who can decide for themselves. So that's the beauty of the French solution, but I accept that it's a minority view at the moment.
Well, thank you very much, Professor Gaillard, for all these insightful comments, for a wonderful presentation. Let's applaud you virtually.
Virtually. I thank you virtually.
And thank you so much for having been with us for this long, more than an hour. And wish you all the best to you, and thank you to the audience, and thank you very much to Paolo and Arnold Porter for having sponsored this event.
Thank you, Horacio and Paolo.
Bye-bye.
Bye-bye.